I'm Aaron Belzer, managing partner of the Civil Litigation Division at Burnham Law. What is Colorado's anti-SLAPP statute? SLAPP is an acronym for Strategic Lawsuits Against Public Participation. Colorado enacted our anti-SLAPP statute in July of 2019, so it's a relatively new statute. There are about 28 other states who have these anti-SLAPP statutes. And a good example of a SLAPP suit, a strategic lawsuit against public participation, is, for example, let's say there's a developer or an entity who wants to build a toxic waste dump in your neighborhood. You and other community members organize to oppose this enterprise from being built in your neighborhood, and that entity sues you, not because there's a meritorious lawsuit, but because they want to distract you and make you burn resources while they're off accomplishing the goal of building the toxic waste dump. You win the lawsuit. Traditional remedy would be something like a malicious prosecution suit afterwards. Meanwhile, the entity can write off the cost of both of those lawsuits as the cost of doing business. And they have accomplished the objective of building this thing in your neighborhood. So an anti-SLAPP statute protects members of the community or citizens who are exercising their right to petition the government, to their right of free speech in connection with a public issue. The statutes are written broadly that we see them asserted as a defense in claims, and we can assert them as a defense in claims, most often for things like defamation. Now, at the analysis under an anti-SLAPP statute, at the first step, the defendant needs to demonstrate that their conduct is an exercise of their First Amendment right in connection with a public issue. If the defendant can demonstrate that their conduct is an exercise of First Amendment right in connection with a public issue, then it's entitled to protection under the statute. Then the burden shifts to the plaintiff to demonstrate that the suit is not a SLAPP suit, that it does have merit. And here, the plaintiff just needs to demonstrate that there is a meritorious lawsuit, that there is some merit to the lawsuit, that there are some facts supporting it. As I said, the law in Colorado is very new. We recently argued the first anti-SLAPP case to the Court of Appeals. So we're waiting for the opinion to come out, and we'll see how courts in Colorado define the burden and the analysis at both of those steps. For more information, please feel free to visit the website, burnhamlaw.com.
Thank you for watching. Make sure you subscribe. And for more information, go to burnhamlaw.com.